Good afternoon, ladies and gentlemen. We've had a very interesting session, and if you go through your invitation cards and schedules, you will not see my name there. So I'm actually a filler. My friend and colleague couldn't come. I was in town from Assam, so मैं stopgap arrangement हूँ.
Introduce yourself.
तो मेरा काम भी थोड़ा स्टॉप गैप रहे तो बुरा मत मानिएगा. My name is Harmeet Singh. I'm an IPS officer of the 1992 batch, and I'm posted in Assam. बाकी क्या बताऊं सर, इतना ही काफी.
Your designation.
So there are too many of them.
What,
So don't laugh. I'm Director General Civil Defence and Commandant General Home Guard. I'm Director Fire Services. I'm Special DGP Police Headquarters with all the police branches reporting to me, including Law and Order. And I'm also Special Director General of Police Border. तो मतलब कोलू का बैल हूँ जिसके ऊपर सब कुछ लादा गया है. But you know, before I start, I want to put something in perspective, that the world is changing and these new laws are actually a very progressive step which accepts that change and prepares us for the future. जब भी कोई नई चीज, you don't mind if I shift between English and Hindi. तो जब भी कोई नई चीज होती है तो 90% of the world is status quoist, वो उसको थोड़ा सा resist करते हैं. And as a result, we first look for the loopholes or the problems that face us and start talking about them rather than seeing the positives of what is in the new. Having said that, I would suggest that we look at the new laws vis-a-vis, as our topic says for today, implementation challenges, where we look for solutions. And I may share with you that just last week there was a nationwide conference hosted by the MHA, the IB, where the highest formations were present, and the result on the session on new laws was as simple as this, that the highest formations involved with this were very clear कि आप लोग जहाँ जहाँ समस्या या बाधा आ रही है उसको काइंडली कोलेट करके और सरकार को पेश करें so that those can be solved. So I would thank the Indian Police Foundation and all of you here today, especially my co-panelists, some of whom are very old friends, we work together, to look at this entire session that the Indian Police Foundation has put together so that recommendations can go as to what those who are knowledgeable and those who are on the ground feel needs to be done. Having said that, I will only act as a moderator. I have very erudite and knowledgeable colleagues here. So I will just list out certain points where we feel that attention is needed, and then maybe start with the lady and we'll come down this way on what. So let me first look at the futuristic aspect of the new law is the amount of importance given to forensics. So where is the challenge here? The challenge here is the manpower and infrastructure required. All states have started working on this, but I think there is possibly a need to speed it up and possibly infuse more funds in it. It's a great thing that we already have a National Forensic Science University. We have other forensic institutes, so the manpower is already out there, they are already graduating. As I said, learning and unlearning of old and new laws is an issue which needs to be done. While we were talking in the last session, there was a young boy who raised the issue of the rights of Divyangs. even as far as this law is concerned, I think a lot of public awareness needs to be brought about. Another thing which came up in the last session is another challenge, which I told the gentleman from Geo कि ये इस session में जैन साहब इसको address करेंगे. Yes, the question of electronic evidence and the amount of digitization that has come out with the new act, particularly the certificate required by experts under section 63B of BSA, the definition and availability of such experts is the challenge that needs to be met. मैं बिल्कुल समझ सकता हूँ कि CDR, SDR, CAF में second फॉर्म भी कौन भरेगा, ये एक सवाल है, but I am sure once this is put up to government, इसका जवाब आएगा. So information from TSPs, ISPs and intermediaries is a question. Now the question is the facilities for audio, video and electronic means at the district, subdivisional and police station level. That is another part of infrastructure. So I am looking at, my colleagues will deal with the entire gamut of the laws and the sections, but I am looking at the systemic requirements because we must look at the systemic requirements. So the facilities for audio, video and electronic means at district, subdivision and police station level is a must, both for witnesses and for recording of evidence. The compulsory recording of search and seizure. पिछली कॉन्फ्रेंस में डायरेक्टर सीबीआई ने और दूसरों ने ये सवाल उठाया कि where you have multiple seizures across the country or across a state running into hours, a raid, आपने वो पिक्चर देखी होगी, raid 3 दिन चली. Now, how do you record something that is going on for such a long time? So that is a clarification and a challenge which I'm sure once it is sought will be available. We already, I think in the last session, Chinese spoke about it, is the practical implementation of the zero FIR. Who actually takes the final call and whether it's a PE or what, that is something that we need to look at. Even electronic summons in a digital form, which is there in the new law. Now, how and where will that get implemented? What will be the SOP? Or as the gentleman and lady, my seniors from UP said, that UP has come out with rules for the new laws. So maybe at the central government level, maybe some forum will suggest to the government that there possibly need to be rules to interpret. Question of receiving information through electronic communication. आपको एक email आया, आपने उस पे EFIR तो ले लिया, but वो असली है या नहीं है is something, because in Assam we had already set up Assam Police Seva Setu, which has the maximum services available anywhere in the country, police services. This question did come up many times. Who will finally sign that thing and how do we verify? So this is a minor point, but as we will be inundated with EFIRs and e-complaints, we will have to handle this. Now, there are all our young legal eagles at the back who are going to join either the bar or the judiciary later. The creation of a prosecution vertical, that is very much a part of the law, but how many states have moved forward, we have to look at that. We have उस दिन दिल्ली पुलिस कमिश्नर साहब ने बताया कॉन्फ्रेंस में, they are moving forward on it. We are creating a service, many states are doing it, but that entire process, कौन होगा डायरेक्टर ऑफ प्रोसिक्यूशन, डेप्टीज कौन होंगे, क्या होगा, उनका स्ट्रक्चर क्या होगा, सिस्टम क्या होगा, that is coming up and that is something which again is not an insurmountable challenge. Everything I'm mentioning here are not insurmountable challenges. So we have to look at the whole thing progressively and look for how do we find the solution, how do we go to government and say on the ground or as per our knowledge, हमको ये addition या subtraction होने से ये फायदा होता है. Registration of PE की बात पिछले सेशन में हुई, I don't want to repeat it. The question, there is another question, ये special executive magistrate का सवाल है. Yesterday we amongst ourselves had a very interesting session thanks to WhatsApp where we exchanged ideas. So this also came up. For other departments there's no bar, but पुलिस में SP के नीचे नहीं हो सकता. Now जिले में तो एक ही SP होता है. So how do we handle that? The courts interpreting what to do pre and post 1st of July. So BNSS पहली जुलाई के बाद हुए केसेस पे लगेगा, या कुछ कोर्ट्स ने कहा है कि नहीं साहब पहले के भी जो प्रोसीडिंग्स है उनको BNSS में ले आइए. So this is a question that will need to be answered. There is also, like the Western countries, developed countries, witness protection is a part of the law. Assam, I know because we are part of it, has already moved. It's under government approval, a witness protection scheme. But witness protection schemes with the concurrent logistics and finances will be needed for witness protection. 377 IPC की बात हो चुकी. I know my colleagues are going to do it again. There's also one more question vis-a-vis sexual offences. The possible misuse of the new section 69, which I think one of my colleagues is going to talk about. The timeline given for postmortems in rape cases is another issue because it's 7 days. So if every doctor starts taking it at 7 days is my minimum, then major cases will have issues, and these days such sensitive cases also have a public reaction. I think there is one more thing that I'd like to point out before I wrap up and ask my colleagues to take over, is the discretion of the SP under 113 to decide whether an offense is under BNS or UAPA. So I think Ashish is going to be dealing with UAPA. In this, of course, I also have to say that central organizations like CBI and NIA have a different investigation sector system and setup than state polices. So how they will also adapt, I think Mr. Jain and Ashish can talk about it. So I think we should start with Chayaji, who will be handling challenges relating to capacity building, her experience of training Delhi police personnel, and issues relating to admissibility of digital evidence as per provision in section 63 of the Indian Evidence Act. So that's all I had to say. तो stop gap का काम थोड़ा stop gap ही होता है. Thank you so much.
So at the outset, I'd like to thank the Indian Police Forum for having given me this opportunity to speak to you. So respected my co-panelists and DC Jain sir and seniors sitting in the audience and my dear friends from the police and the legal fraternity. I was looking after training, and just the day I joined as special CP training, I was asked to create material for 90,000 police officials of Delhi police, and so that they understand the new laws. So at that point in time, when 25th December, just the bill had come, I had copies of the bills only, and not even the actual act had come. Printing, it had been enacted, but the print had not happened. So we had just one copy of the taxman, and that was all that we had. And CP sir told me that I have to go and create books or maybe some material so that the lowest common denominator in our department understands what the new law is. So first of all, it was a big challenge. Thanks to sir, he allowed me to create a small team. We included a lot of officers who knew law, some seniors, some juniors, some retired personnel, and 2-3 advocates also, so that they become our devil's advocate. And we told them that आपके पूरी freedom है, हम जो करें आप हमें question कीजिए, and please make us uncomfortable, because we don't want that our books should go out and people should laugh at us that what have you created. And we also realized that अभी तक जो पढ़ाई हो रही थी उसमें बेयर एक्ट लेके जो हमारे टीचर्स थे, लॉ के ट्यूटर्स थे, वो पढ़ा रहे थे, बट दे वर यूजिंग द बेयर एक्ट. सो टेक्निकली हैंडबुक कोई नहीं थी जिसमें हम पुलिस को पुलिस के बारे में पुलिस के तरीके से पढ़ाएं. सो दैट गैप वी हैड टू कवर. सो हम लोग बैठे, करीब 28 दिसंबर से हमने बैठना शुरू किया, और बिफोर 26 जनवरी हमने 3 हैंडबुक्स क्रिएट करी, जिसमें एक हैंडबुक BNS पे थी, एक BNSS पे थी और एक BSA पे थी. तीनों हैंडबुक्स का जो अल्टीमेट मीनिंग था, द फील वाज दैट इफ some ASI or a head constable, even if he's about to retire in 2 years, should not feel uncomfortable. He should be able to hold the book and understand what is my job and how do I have to go about it. What are the sections? What has the change come? Because now if you take the bare act, you wouldn't know what the change is because it's not highlighted, it's not given separately. It is the act. Now it's the new act. So what we did was we abridged sections from the act where we felt that change is there. We put it in color and we highlighted those portions so that it is easy to make out. And then we gave comments. So we made those booklets pretty early. And then by now, we also created a compendium of 20 scenarios, like what happens if it is a snatching case. So our CP sir had given us the guideline that we have to create a guide, something like an idiot's guide, where anybody who doesn't know anything about how he would have to register a FIR, and like Shiny was mentioning, right from the time a call or information comes to the police station, up to the fact that the final chart sheet is made, what he has to do, all step-wise guide. So that we identified 20 scenarios initially, and we made that step-wise guide, largely based on Tamil Nadu's writer's card. And after having said that, we made sure that what we started doing was that we made a compendium, like whatever forms they would be needing for the new, we made those forms also. And then we started a phase-wise process. How do we start teaching our guys, like which segment to start first? Because in January we thought it was March that they will start implementing it, but then it later on, as it luck would have it, it happened in July, 1st of July. So we did phase-wise. First, the cutting edge. Second, the people who may be in traffic or armed police, well, again we will be meeting, and we made sessions for them, 5-day sessions, and we taught all the 3 laws. The first most important challenge that we needed to take out the fear was that it's not like a unsurmountable thing. It's something which is easy and it is possible for them to do. So having said that, I think I've been very lucky, a lot of support, and we were able to do this because we did trainers. We identified good officers from districts, and we created 45 master trainers. They trained the first lot of our cutting edge people from all over the thanas. So by the time it was March end, they were ready. Suppose any new FIR needed to be registered, they would be able to do that. And also, the biggest challenge was that in the training academies, we were now had to teach not only the new law, but the old law also. Because for another 5, 6 years or 10 years, you will still have to deal with the old laws also. So this was a big challenge. Having said that, we were able to incorporate stakeholders also, and that was very important. First the prisons, then the NAIB courts, then the newly recruited magistrates. We tied up with the Judicial Academy. So a lot of things we did, and we made sure that whoever and who was ready to learn from us, we were able to give them training. And lastly, we trained about 80 executive magistrates also from the Delhi government. So having said that, I'm supposed to speak on admissibility of the digital evidence. So a lot of portion I think Shiny had covered, but as and when we speak on that, when we will speak independently, I will speak. But the most important part that we have to understand is that digital evidence has created a lot of procedural issues for us, challenges for us, how we will pick it up, how we will record, and how we will make it admissible in the court. This bit about hashtag value, the integrity of chain of command, how we're going to store it, where we're going to store it, is it going to be primary evidence, secondary evidence? So all that we will discuss, and as and when we progress through our this thing. Thank you, sir.
Before I pass the floor on to Anil Kishore Yadav, who will speak on proclaimed offenders, trial in absentia and related issues. On the training part, Chaya, I just have a query for you, and it involves everybody in the house. that while on the judicial side there is an equal amount of training going on, and while on our side, the police, there's an equal amount of training going on, there are other stakeholders like the civil administration and the health authorities, because the health authorities play a very major role. So did you move towards that and do something there, or are other states doing, so later my other friends can also handle this question, because if everybody is not on board, all stakeholders are not on board, then we will continue facing roadblocks.
So I agree. We have this medley power also, I think, which needs to be activated, which is not in place right now, where the reports, the medical reports, have to come in a time-bound manner. So once that gets enforced, only then we can force these people to come and have, because it's only a very short part of the new law which we will have to cover. But we are in consultation with the senior officials of the main hospitals in Delhi. But I think once they are ready with the medley power issue and they're able to provide that, I think only then they will come for training. So as of now, not the medical fraternity.
The floor is all yours.
सर थैंक यू सर. इसमें छाया वाली मैं इसी बातों में थोड़ा एक जोड़ना चाहूँगा. हम लोग CAPT सेंट्रल एकेडमी फॉर पुलिस ट्रेनिंग इन भोपाल under BPR&D, we have been conducting these capacity building programs for 5 major pillars, and also sir we are going to plan a national level this conference, 2 days conference on 7th and 8th October. There we will call medico legal experts also, those doctors who are handling those autopsies, postmortem reports and all those. Sir, thank you. Jai Hind, madam, sirs, or dear students. I would like to talk about related issues, proclaimed offenders. Proclaimed offenders is one of those most enabling reforms. Earlier, पहले हमारे IPC की मात्र 19 sections defined थे under section 82 subsection 4 CRPC. उसमें proclaimed offenders डील करता है 82 section CRPC का. अभी section 84 है BNSS का. उसमें 4 subsections हैं. Subsection 1 to subsection 3 there is no change at all. CRPC and BNSS there is no difference. But there is huge difference in subsection 4 of these respective corresponding provisions. So what has happened with this new reform? This scope of proclaimed offenders, it has been expanded limitlessly. Under section 82 subsection 4 of CRPC, there were only 19 specific sections of Indian Penal Code were mentioned, जिसमें रॉबरी, डकैती और मर्डर इस तरह के सेक्शन, और मिसचीफ थ्रू फायर और एक्सप्लोसिव्स, इस तरह के सर्टेन मोस्ट सीरियस सेक्शन जो उन्होंने कंसीडर किए, उन्हीं के लिए प्रोक्लेम्ड ऑफेंडर्स वाले प्रोविज़न उसमें थे. लेकिन अभी 82(4) सबसेक्शन 4 BNSS में बाय रिप्लेसिंग दीज specifically mentioned provisions, they have provided making it applicable to all offences punishable for imprisonment for the term of 10 years or more than 10 years, life imprisonment and death penalty. So by a single stroke, this is going to expand this scope limitlessly. 19 की जगह पर हमारे not only these हमने उसको enumerate किया, तो there are 85 sections in the BNS itself जहाँ punishment 10 years or more than 10 years LI and death penalty तक जाता है. तो 85 19 की जगह 5 गुने तो यहाँ हो गए, and this will be applicable to every law for timing and force. सभी special acts पे भी लागू होगा जहाँ भी 10 साल से ज़्यादा जिन offences में सज़ा है 10 या उससे ज़्यादा. तो ये इसका विस्तार बहुत हो गया है. इसका फ़ायदा जो प्रोक्लेम्ड ऑफेंडर से रिलेटेड प्रोविजंस हैं, लाइक सेक्शन 34 BNSS, जहाँ विलेज ऑफिसर जो भी रिलेटेड हैं उनको सबकी रेस्पॉन्सिबिलिटी रहेगी प्रोक्लेम्ड ऑफेंडर कहीं उनके इलाके में कहीं आने जाने की सूचना है तो वो रिपोर्ट करेंगे, इस तरह की जो चीज़ें हैं। इससे भी बड़ा इसका बहुत ही क्रांतिकारी जो एक और हमारा इनोवेशन है हमारे इसमें, हालांकि इंडियन सब कॉन्टिनेंट में दैट इज़ 1982 में बांग्लादेश वाज द फर्स्ट टू इनोवेट ऑन दैट अकाउंट, ट्रायल इन एब्सेंसिया। उन्होंने 1982 में सेक्शन 339B कैपिटल एंड कैपिटल C 339, उसके माध्यम से उन्होंने, उनका वहाँ वही अंग्रेज़ वाला ही चला आ रहा है CRPC 1898 वाला, उसके माध्यम से उन्होंने किया था। और अपने यहाँ झारखंड में कोड ऑफ क्रिमिनल प्रोसीजर अमेंडमेंट एक्ट 2020, जो कि 22 में झारखंड का एक्ट नंबर 6 है, उसके माध्यम से उन्होंने सेक्शन 299 CRPC में अमेंडमेंट करके उसको लेके आए। और हमारे यहाँ जो 356 है ट्रायल इन एब्सेंसिया, उसमें प्रोक्लेम्ड ऑफेंडर के लिए है बाय डिफ़ॉल्ट, लेकिन लॉ मेकर्स ने इसको रखा है सेक्शन, जिसका लास्ट सेक्शन सबसेक्शन 8वां है, उसके माध्यम से स्टेट गवर्नमेंट्स को एम्पावर्ड कर दिया है मात्र नोटिफिकेशन के माध्यम से ही इसका विस्तार बढ़ाने का, जो नॉट ओनली प्रोक्लेम्ड ऑफेंडर्स के जो प्रोविजन है 10 साल वाले, बल्कि सबसेक्शन 1 के अधीन हैं जो प्रोक्लेम्ड पर्सन वाली कैटेगरी में आते हैं, उन पर भी सर्टेन ऑफेंसेज या उनकी कैटेगरी ऑफ ऑफेंसेज में वे विस्तारित कर सकेंगे स्टेट गवर्नमेंट्स। तो ये ट्रायल इन एब्सेंसिया के माध्यम से, जैसा सुबह के सेशन में भी उनमें भी बात हुई, बाहर हैं हमारे देश से या फिर हमारे देश के अंदर हैं और वो थकाते हैं सिस्टम को, फटीग, विक्टिम और विटनेसेस को, और उसके बाद में अपना बाद में फेवरेबल जब टाइम आता है तब सरेंडर करेंगे या पकड़ में आएंगे, तो ऐसे में हम कर सकते हैं। लेकिन यहाँ एक मैंने जो अनुभव किया उसके हिसाब से एक वर्ड ऑफ कॉशन है हमारे सभी जो स्टेक होल्डर्स हैं इसमें हैं क्रिमिनल जस्टिस डिलीवरी सिस्टम में, कि जैसे कन्विक्शन इन एब्सेंसिया किया जा सकता है, वैसे ही सर्टेन इन्फ्लुएंशियल और शातिर जो प्रोक्लेम्ड ऑफेंडर्स हैं वो एक्विटल इन एब्सेंसिया भी पा सकेंगे अगर हमारा सिस्टम बहुत अलर्ट नहीं रहा। इसलिए ये इशू मैं फ्लैग करना चाहूँगा इस फोरम के माध्यम से। और इसमें मैं याद दिलाना चाहूँगा कि कुछ बहुत ही अच्छे इनेबलिंग प्रोविज़न हमारे एक्ट 25 ऑफ ईयर 2005 के माध्यम से, जो 23 जून 2006 से लागू हुए थे, वो लागू होने के बावजूद हम उसका फ़ायदा नहीं उठा पाए, जो फरार रहने की प्रवृत्ति को कर्व करने के लिए लाए गए थे। 23 जून 2006 से लागू थे और वो यहाँ भी आए हैं। सेक्शन 174A इंडियन पिनल कोड, जो यहाँ थोड़े से संशोधन के बाद 209 BNS के रूप में आ गया है, उसका तो कुछ राज्यों में प्रयोग हुआ भी, हाई कोर्ट्स, इलाहाबाद हाई कोर्ट्स, दिल्ली हाई कोर्ट और चंडीगढ़ हाई कोर्ट के जुरिडिक्शन में प्रयोग भी हुआ। और बहुत ही मेजर केस लॉ जाए, संजय सरीन वर्सेस UT ऑफ चंडीगढ़, इकबाल वर्सेस UP, मोती सिंह सिकरवार वर्सेस UP, कृष्णा रेड्डी वर्सेस CBI, दिल्ली हाई कोर्ट, इस तरह के। लेकिन इनके अलावा हमारा बाकी पूरे देश में इनका यूज़ नहीं हुआ है। और एक और उतना ही अच्छा आया था बेल जंप वाला 229A, जो कोर्ट को करना था। इतने लगभग 2000 जुडिशल ऑफिसर्स को हम लोग इस बीच में इसमें कर चुके हैं ट्रेन, उनमें से एक भी ऑफिसर नहीं मिले जिन्होंने बताया हो कि उन्होंने खुद या उनके किसी परिचित ने उन्होंने सुना है कि उसका कभी इस्तेमाल हुआ। ये टू कर्ब दी टेंडेंसी टू इवेड अरेस्ट एंड ट्रायल, ये चीज़ थी। तो 229A 269 BNS के रूप में आ गया है और 174A यहाँ 209 के रूप में आ गया है। और 174A के साथ एक कंट्रोवर्सी क्रिएट कर दी गई थी, जो सेक्शन 195 सबसेक्शन 1 CRPC के माध्यम से, कि भाई कि इसके अंदर आएगा इसलिए ये कॉग्निजेबल ऑफेंस के रूप में ऐसे ट्रीट नहीं होगा। लेकिन वो कंट्रोवर्सी इस नए कानून ने पूरी हमेशा के लिए सेटल कर दी है। उन्होंने न सिर्फ 209 को यहाँ टच किया, उसमें कम्युनिटी सर्विस वाला एक एडिशनल डाला है फर्स्ट पार्ट के लिए, उन्होंने सेक्शन 215 BNSS which is corresponding section to 195 of CRPC, they have clearly mentioned that excluding section 209 of भारतीय न्याय संहिता। तो अब हमें किसी तरह कन्फ्यूजन की गुंजाइश नहीं रही है। अब हम लोगों को ये कॉग्निजेबल ऑफेंस है। तो 209 और 269 जो सेक्शंस हैं बेल जंप के, 269 कोर्ट के वहाँ से शुरू होंगे और ये नॉन अपीयरेंस प्रोक्लेमेशन का डिफाइंस है। तो इन पे हमें कार्रवाई करनी होगी, FIRs दर्ज करने होंगे और उसमें कई केस लॉज हैं। समय कम है तो उसके बारे में डिटेल बात नहीं करना है। उन केस लॉज में ऑप्शन सारे हैं, फ्रेश एफआईआर आपको करनी है 209 में, या उसी चालान में ही उसमें ही सप्लीमेंट्री चार्ज जोड़ के आगे बढ़ा देना है। वो सारी तरह के केस लॉज हैं, ऑनरेबल दिल्ली हाई कोर्ट से लेके ऑनरेबल चंडीगढ़ हाई कोर्ट और ऑनरेबल इलाहाबाद हाई कोर्ट की। तो मुझे बस यही हाईलाइट करना था कि कहीं ट्रायल इन एब्सेंसिया का फ़ायदा हमसे पहले कि ट्रायल कन्विक्शन इन एब्सेंसिया के बजाय वो एक्विटल इन एब्सेंसिया लेके न चले जाएं और हम जब तक जागें, और हम 12 साल में हमने बहुत अच्छा इस्तेमाल नहीं किया उन कानूनों का, 23 जून 2006 से लागू हैं। ये मैं फ्लैग करना चाहता था। थैंक यू सर। जय हिंद सर।
I think you might as well pass that one. Thank you, Anil. Now hand over to Viplav Kumar Chaudhary, Joint Director CBI. I'm very happy to note that he has, as part of his mandate, provisions helpful to the IOs in investigation. As I said, we have to look at the entire gamut of the new laws positively. The other issues he will be handling is decriminalization of 377 and the audio-video recordings of such provisions, which we've already mentioned. The floor is all yours, Viplav.
Thank you, sir. Sir, it has been less than 3 months since the new criminal laws have come into effect, and I am little positive. Positive in the sense that, based on our experiences so far, we can safely say that the challenges in implementation of the new laws, so far as investigation is concerned, have been far too less than what had been anticipated. Transition has been quite smooth, at least in the organization I come from.
Even as far as we are concerned.
Sure. Some of the provisions of the new laws have in fact been quite helpful in police investigations. For instance, provision contained in section 187 of BNSS, which provides that after arrest, police custody of an accused can be taken for a maximum period of 15 days in the whole or in parts at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days, as the case may be. In case of central agencies or even in state CBCIDs, case will come to, let's say, CBI or to NIA or to, let's say, state CID also after about 2 months, 3 months, 4 months, maybe after a long gap. So the initial 15 days already lost, and when the case will come to us after 15 days, then the advantage of custodial interrogation is lost. So by providing this provision, probably we have got some advantage. Secondly, provisions contained in section 193 of BNSS, which provides that on completion of investigation, police report along with other documents can be given to the accused by electronic communication also. Again, this is in cases that we handle in CBI particularly, a lot of documents are there. Sometimes the number of accused is also very large. So it becomes a problem to provide them all the documents, the police report in physical form, in hard copy. Now it is very easy for us to give it to them in a simple pen drive.
Only if he agrees to take it as electronic. You can't force it on him. Kindly check this.
No, you can.
You can't force it on him. Only
No,
if the
he
person
can't
agrees.
demand that it is to be given in the document form only. Because the law is very clear that if you provide it in the electronic form, it will be considered as duly served.
It will be
But he
considered.
can't say no,
It
sir.
doesn't necessarily mean that you have the authority to give it, because the person can be quite poor on the other side and he says, मैं print out कहाँ से निकालता रहूँगा? I require them. So this is an interpretation.
फिर वो कोर्ट का भी तो रहेगा ना सर रोल. I think there I think
ये
the
तो
court
court
will
का
have
role है.
court का रोल
नहीं,
रहेगा.
नहीं, कोर्ट का रोल नहीं है, because अब इसमें clear हो गया कि the IU has to provide all the copies.
नहीं, but through the court only, not directly.
Through the court.
Through the court only.
मतलब it's not necessary कि हो जाएगा, it's a matter of.
जो लैंग्वेज है सर, उसके हिसाब से तो कैन इवन बी प्रोवाइडेड.
हाँ.
So it is of course not necessary that we provide everything in physical. But then generally they have been accepting it.
कभी कोई objection आएगा तो case law बन जाएगा.
वो भी है सर. अब नई चीज़ें आई हैं, जुडिशियल इंटरवेंशन होंगे एंड देन.
ठीक बात.
एक अगला प्रोविजन है सर, which is contained in 187 of BNSS, which provide that an accused can be produced before a magistrate for extension of judicial custody even by audio, video, electronic means. Again, पहले हम लोग जब ले जाते थे इन्वेस्टिगेशन के दौरान तो इतने सारे लोग लगाने पड़ते थे, so that problem will be sorted out then. So having said that, I must also point out that there are some gaps, some issues, though not very serious but significant enough, warranting our attention and needs to be addressed. A case in point is absence of provisions in BNS corresponding to section 377 of IPC, which criminalized and provided punishment for unnatural sex with any man, woman or animal. This section has been discussed in the previous session also, but just to briefly touch upon. Honorable Supreme Court in the 2018 case Navtesh Singh Johar versus Union of India read down section 377 of IPC and decriminalized consensual sexual relationship between consenting adults, whether between same-sex individuals or otherwise. After the said judgment, section 377 of IPC continued to apply to non-consensual unnatural sexual acts for acts like sodomy and bestiality. The recently enacted BNS prescribes punishment for non-consensual unnatural sexual acts by a man with a woman. Also, there are penal provisions in POCSO Act, which is gender neutral, for non-consensual unnatural sexual acts with a child. But in the absence of any provisions corresponding to section 377 of IPC in the BNS, at present, there is no remedy under law for non-consensual unnatural sexual acts by a man or by a transgender person with a man or a transgender person above 18 years of age. So that's an area of concern. I am, however, sure that with time, by judicial interventions as well as by legislative enactments and executive orders, such gaps would be quickly filled. One major issue related to investigation, which is being faced at this early stage of implementation of the new criminal laws, is related to the provisions contained in section 185 of BNSS. We talked about this provision earlier also, in the previous session also. This section makes it compulsory to record search proceedings during investigation through audio, video, electronic means. This section further stipulates that recording of search be conducted preferably by mobile phone. My take is that instead of use of the word including, that is to say that probably we could have used word including instead of preferably. So that is to say that recording of search be conducted through audio, video, electronic means including mobile phones. Instead of saying recording of search be conducted through audio, video, electronic means preferably by mobile phone. So probably that would have been better. Nevertheless, recording of such proceedings by mobile phone or by any audio, video, electronic means such as by a video camera in searches, which sometimes continue for long hours. In case of CBI cases, sometimes we conduct searches for 10 hours, 15 hours, 20 hours, days together. So that becomes sometimes very quite challenging, because you have issues such as discharge of camera, discharge of mobile phone, battery discharge, even video camera will also not function for such a long time. There are issues related to storage capacity of the mobile phone or the video camera also. But I am sure again that with time we will develop adequate infrastructure for videography of such proceedings, and we will overcome this issue also. Thank you.
Now may I request my friend Ashish Chaudhary from the NIA, who's an IG in the NIA, to talk to us about UAPA and BNS, because as you all know that anti-national elements raise their head every few days, and Ashish is one of the people handling that part of protecting national security. All yours, Ashish.
Thank you so much, sir. First of all, I think the benefits that are going to arise out of these new laws and the related changes in the criminal jurisprudence is being well appreciated everywhere. Being one of the key stakeholders, the police, there was definitely initial hiccups, there was certain hesitation, but as we all know, no major change can be had without any hesitation. So the larger and the bigger the change, there's more resistance to it. But what is heartening is that the way these laws have been drafted and enacted, there is very less which needs to be modified and addressed to. When we were having these closed group discussions on this topic with regard to the changes and the difficulties which are being faced by the law enforcement agencies, I would say that there were not many difficulties and issues which require a larger intervention. So these are small little interventions which may be, from executive orders, maybe some certain SOPs, these can be addressed. Yes, there were certain issues which we cannot, as on date, say that they have been resolved. Our issues with regard to, number one, the searches, as has been mentioned. Not only the searches in large number of locations when the searches are being considered, and especially when they are protected in time, these issues will come up. Another thing which probably 105 may have missed is the chance recovery. So if I'm a policeman on the ground and I see something happening in which I have to seize certain material, let's say I see somebody carrying drugs or illegal arms, what do I do there? Do I start recording it? Do I secure the person? Do I first secure the contraband or the illegal stuff? And if at all I have to do, how can I do it? I don't have too many hands. So, and will this act of mine, become a reason for the person to get away? But I'm sure all these will be taken care of in the suggestions. And as has already been mentioned by Sir, the highest formations of the government and the stakeholders that we are already seized of these matters, and a very high level committee is going to look into all these, and certainly all these problems are going to be addressed to. One thing which I wanted to highlight over here is, as you all know, and probably the students of law which I can see over here would have been exposed to, the terror law of this country, the UAPA, is a special law which was enacted because the IPC, which was the major criminal law, did not have specific sections and offences with regard to terrorism. Now, under section 113 of BNS, this terrorism has also been made an offence in the criminal law, which is a very, very welcome sign. But what is required to be seen is that UAP is not only a penal law, it is also a procedural law. It lays down a lot of procedures with regard to how the UAPA has to be, implemented. What are the rights and, overarching liabilities, I would say, with regard to the accused. There are certain provisions which empower the law enforcement agencies in terms of more number of days for police custody, the larger detention period. The provisions of bail are a little stringent as compared to the normal law. So all these have to be also, somehow linked to the section of 113, the offence which has now been incorporated into the main criminal law. Because if there are same offence, two different laws, two different statutes, it may invite unnecessary litigation and maybe even challenge on the constitutionality. But I'm sure this has also been highlighted, and this shall also be taken care of in the due course. And obviously we have the issue with regard to the admissibility and the certificates of 63A and B. The definition of expert, as has already been dwelled in detail in the earlier session, this needs to be also taken care of, sir. That is all from my part. Thank you so much.
may I now request our esteemed senior, Shri DC Jain Saab. He's touching upon three very important aspects. One is the question of how the courts are handling the post and pre-1st July 2024 situation. Then the prosecution vertical, which will be the backbone of the entire investigation, and then later taking it to the courts. And of course, the question of exempted categories, which may lead to further confusion. So I hand it over to you, sir.
Thank you, Harmit. Before I begin, we must acknowledge the presence of Director Prosecution CBI, Dr. Padmini Singh. On our request, is here. So thank you, ma'am, for accepting our request. To respond to the question, there are a couple of, I think again, no law is perfect. We all know Dr. Ambedkar, like after making the constitution, the remarks, I think he said no law is perfect. Only the people who administer the law makes it perfect or imperfect. So a lot will depend upon the people who are going to implement the new criminal laws. So obviously in any bare act you can't find answers to all questions because they are subjected to multiple interpretations, and I think these new criminal laws are no different. We need to appreciate 1860 IPC. Even today the high courts and the Supreme Courts, they are giving different interpretations. Even today, in fact, we have to go to the court and seek clarification. It means there was some clarity lacking in even in those laws. So these laws have just they are not even old by 3 months. Coming to the issues that I need to point out, again, interpretations in section 20 of the BNSS, like it was introduced in the opening remarks also, in order to strengthen the prosecution, they want the state government to set up directorate of prosecution at each district level, district headquarters. Now they have also defined the powers and functions of the 3 officers of the prosecution, that is the Director of Prosecution, Deputy Director of Prosecution and the Assistant Director of Prosecution. Interestingly, in case of the Deputy Director of Prosecution, they say one of his functions would be to examine and scrutinize the police report. Now this can also be subjected to different interpretations. We already have a notification issued by the Union Territory of Jammu and Kashmir on this. What do we mean by police report? Whether the investigation report before it is filed in the court under section 193 or after that. So the Jammu and Kashmir notification, those who have looked at it, it says after the police report has been filed in the court, then the Deputy Director of Prosecution will examine and scrutiny. But I wonder, once you have already submitted your report in the court, thereafter what kind of examination or scrutiny the Deputy Director can do? Because it becomes now a court matter. So I think these things need to be, but fortunately the same section gives the powers to the state to kind of, issue clarifications and notify any more powers and functions of these 3 functionaries. So I think this gap needs to be filled and this clarification need to be issued. Now this next thing, the changes made in section 179 BNSS, when we compare it to the corresponding section 160 of CRPC, are very, very important for the police officers in the field. What it is, as we know, section 160 of CRPC empowers us to summon a person for examination at the police station. There are certain exempted categories you can't call to the police station. We all know, women of any age, an elderly person 65 years and above, a male child below 15 years, and the 4th category is people who are mentally and physically challenged or disabled. What changes have been made in corresponding section 179? The age of the male person has been reduced from 65 to 60 years, and they've added one more category, persons with acute illness. Now this thing has again not been defined in 179 whom you will treat as the person suffering from acute illness, but what is important is the new proviso that has been added in section 179. What it is, that if any one of these exempted categories of people make a request to the police officer that you don't come to us, we want to attend the examination at the police station, then the police officer will be able to do so. Now I see here certain practical issues in the sense that may put them into trouble in the future. How do you implement it? Whether the person makes an oral request, you also permit orally, and if it happens to be any particularly a child or a female who is made to visit to the police station for the purpose of examination, tomorrow, if they make a complaint that no, we were forced to attend at the police station, that what defense you have? Why I am saying so? Because we must all know, if the police examines any person at the police station in violation of the direction of law, it is a cognizable offense. Not many people know that. Section 166A of IPC and the corresponding section in the BNS is 199. Incidentally, no protection under section 197 for this offense, because it is exempted from 197. Again, the corresponding new section is 218 BNSS. So we have to be careful. We must insist, if any one of these exempted categories of persons makes a request to the police officer that I want to attend the examination at the police station, my advice would be, please seek in writing. You must have the evidence on record that the request came to me in writing, and you must also permit in writing. So that tomorrow if anyone tries to drag you into any kind of controversy or problem, because you have the defense with you, because of this problem, that violation is a cognizable offense. That is one. Then, there is a provision 193 of BNSS. The corresponding section is 173 of CRPC pertaining to filing of police report in the court. Further investigation. Power of police to continue further investigation even after filing charge sheet. There is a change. No, again, a proviso has been added where they say, if you want to continue further investigation during trial, then you require permission of the court. This was not there in the CRPC. So what do you mean by during trial? Moreover, there are a couple of questions that need to be clarified by the police leadership, in the sense that when I file a charge sheet under section 193(9), and while filing the charge sheet, I keep further investigation continued. And if I am not able to complete this further investigation and the trial begins, whether I require permission of the court in this case, or after having filed a complete charge sheet, if I think because of whatever reasons that I need to now do further investigation but the trial has begun, is it in this case that I need to obtain permission of the court? I think these are the issues that need to be clarified. Last, applicability of BNSS versus CRPC. We all know, when you read this section 531 subsection 2, one thing is, it says those proceedings which are pending, whether it is investigation, whether it is trial, whether it is appeal, and it also includes any application, they will be continue to be governed by CRPC, as if this BNSS did not come into existence. But if we read, there are already different verdicts of different high courts on this. Say for example, Delhi High Court in one case says, this particular FIR was registered much before 1st of July 2024. Now, during the pendency of investigation, the accused person moves an application for anticipatory bail in the High Court. Now, High Court judge say this should have been moved under BNSS because it is a new application. It is not a pending application. So, but the investigation began before 1st of July 2024. This application has arisen out of that investigation which is pending much before 1st of July 2024. Similarly, in another judgment of the Punjab under Haryana High Court, where a person had filed a revision petition in a matter much before 1st of July 2024, but along with an application for condonation of delay. So what the judge does, first he decides the application for condonation of delay, that is allowed. Now the judge says, since I have allowed this application today, therefore, the revisional application or the petition has to be filed under the BNSS. I will not consider what was filed earlier under the CRPC. But in the same High Court, very recently, few days back, another judge doesn't agree with this interpretation of the earlier judge, and now this matter has now been referred to the Chief Justice for constitution of a larger bench. Look at the Rajasthan High Court, what they say, Rajasthan High Court, that no, as far as the previous matters are concerned, whatever may be the stage, whether it is investigation, then it moves on to the trial, then moves on to the appeal, all the subsequent stages will also continue to be governed by CRPC. So there is continuity, there is not confusion. Otherwise, the judges as well as the advocates, in the same matter, somewhere they'll have to refer to the CRPC, somewhere they'll have to refer to the BNSS. So why to create so much confusion? Let us deal with old matters under the CRPC and the new matters which will arise after 1st of July 2024 under the BNSS. So as you can see, different high courts have already been interpreting these things, I think, differently. So either the central government may consider issuing clarification or make rules, or it is the state leadership who looks at these pending issues. So I think, as I said in the morning also, a lot will depend upon how the state and the police leadership handles these issues or concerns arising out of the interpretations of the new criminal laws. Thank you.
Thank you, sir. I think we can now open the floor for questions. Please.
May I, sir?
बिल्कुल.
ये पूरा सुनने से लगता है कि this whole thing, new law, is in a stage of draft, and there will be amendments. Am I correct? Number one. And if there is any amendment, it will go to the parliament again. So is that going to happen?
No, it depends. You see, पहली बात तो these are laws, these are not drafts. है ना? They have been enacted by the parliament. They have become codes. Gazette notifications issued. They have acquired the status of a law of the land. As far as amendments are concerned, amendments can always, like in a criminal law, because it is a subject matter of concurrent list. So both the states as well as the union have powers to amend these laws, depending upon their requirement, their powers, etc. Okay. So even the state governments can make state-specific amendments. In the earlier laws also, there were many amendments done by the respective states. So here also, there is no legal bar by the state to amend it. As far as the union government is concerned, they are also, I think, within their powers either to amend or issue clarifications to the rules, as has been discussed. So I think, as Harmeet was saying, only on 13th and 14th of this month, there was a high-level conference in the Intelligence Bureau, which was attended to by the highest formations. So they are now, I think, gathering. They have requested all the stakeholders to kind of consolidate and get back to them, and then perhaps they will take a call.
So it will not go back to the parliament?
No, amendment, for amendment, they have to go back to the
अभी जैसे इन्होंने कहा that courts are still interpreting the old laws. So law is always a ruling, a rule, an interpretation, a clarification, and then if need be an amendment. So it's a process. आप डायरेक्टर प्रोसिक्यूशन से इसके बारे में चाय पे चर्चा कर सकते हैं.
My question is, what happened to that section 304A of IPC, which was there in the BNS, which has been shelved? Generally, an act should be shelved by the Act of Parliament only, but it has been done by an executive order of Secretary or I think MHA. I would like to know about that. And as of now, I think 304A IPC cases are registered under 304A IPC only now, because the new act things have been shelved. It came in papers and what is the situation? I don't know.
Confusion is there, sir. Let us be very clear about it. 304A IPC makes the act of death due to rash and negligent act an offence. What has been changed? There is a corresponding section in the BNS, that is 106 BNS. There are two subsections, 1 and 2. 1 is very clear. It is the one which is corresponding to 304A, जो कहता है कि अगर आपने accidental death किसी की कर दी तो change क्या हुआ है? Definition stays the same. Punishment has been increased from 2 years to 5 years. पहले यह था कि maximum punishment 2 साल हो सकता था, अब वो 5 साल तक उन्होंने कर दिया है. उसमें एक exempted category रखी है जो death due to medical negligence, डॉक्टरों के केस में, that will still attract the maximum 2 years punishment. ये हो गया 106(1). 106(2) में now they have added a kind of new offence we can say, जो hit and run accident cases की आप बात कर रहे हैं, कि अगर वो व्यक्ति डेथ करके रिपोर्ट नहीं करता, इन्फॉर्म नहीं करता और भाग जाता है, hit and run, तो in that case the maximum punishment can go up to 10 years. तो इसको लेकर के हल्ला हुआ था कि ये बहुत ज़्यादा ड्रिकोनियन हो गया है, बहुत ज़्यादा हो गया है, कुछ स्ट्राइक वाली बात भी हुई थी, कुछ हुई भी थी ट्रांसपोर्टर्स की स्ट्राइक। सर, लॉ के प्रोसेस में क्या होता है, एक बार जब लॉ पास हो जाता है, प्रेसिडेंशियल असेंट मिल जाती है, तो ये सेंट्रल गवर्नमेंट का प्रेरोगेटिव है कि वो उसमें से किसी भी पार्ट को रोक सकता है। जब तक वो गजट नोटिफिकेशन नहीं करेगा तब तक वो लो इट विल नॉट कम इन टू इफेक्ट, बिकॉज क्या लिखा रहता है, इट विल कम इन टू इफेक्ट फ्रॉम द डेट विच द गवर्नमेंट ऑफ इंडिया शैल नोटिफाई। तो दैट डेट इज डिसाइडेड बाय द गवर्नमेंट ऑफ इंडिया थ्रू अ गजट नोटिफिकेशन। इस केस में इन्होंने क्या किया, 1061 को तो नोटिफाई कर दिया, 1062 का नोटिफिकेशन विदहोल्ड कर लिया, तो दैट हैज़ नॉट कम इन टू इफेक्ट। तो आज की तारीख में इवन अगर हिट एंड रन के डेथ केसेस रिपोर्ट होंगे तो 1061 में ही किए जाएंगे, 1062 अभी अप्लाई नहीं होगा।
We'll take another couple of questions.
Sir.
Then we need to wrap up.
May I, sir?
I think the gentleman at the back was first. Can we allow him?
Yeah, thank you. My name is Valay Singh. I work with the India Justice Report. So I would first like to thank IPF for giving us this opportunity, and also the two panelists, I mean the two panels. My question is very simple, and it's also a long-standing question which all government officers are aware of. Is this also not critically linked to the capacity, the implementation? So that's one question. Do you think that we are in a, I mean, with just 19 lakh actual policemen in service, do we have the capacity to do justice to the expectations that are there in the new acts? That's one. The second is that what happens if the judge actually adjourns and does 3 hearings? Or if the police officer, as Mr. Chaudhary was saying, is not able to record, make a video recording. So what is the accountability for that? These are my 2 questions.
On your first question, I have a simple reply: yes. We are absolutely capable. Capacities have been brought up. On your first question, it's an unequivocal yes. Capacities have been brought up. Capacities are being brought up, and 19 lakh is a very large number. So yes, we are absolutely capable of handling it. The technical part, Anil will handle.
Thank you, sir.
Police to population ratio in the world.
That's we chai pe charcha mere bhai.
This, if any public servant disobeys direction under law, that as sir mentioned already, that is a cognizable offence under section 199 BNS. निर्भया केस के बाद में जोड़ा गया था, 3 फरवरी 2013 से लागू था, 166 A IPC था, वो पूरा का पूरा रिप्रोड्यूस्ड हो गया है 199 BNS के रूप में। तो कोई भी पब्लिक सर्वेंट है जो क्लियर कट डायरेक्शन है अंडर लॉ, डिसोबेइंग डायरेक्शन अंडर लॉ नोइंगली, तो उसके हिसाब से उसमें उनके खिलाफ मुकदमा भी दर्ज किया जा सकता है। और इसमें टर्म यूज हुआ है पब्लिक सर्वेंट, इसमें यहाँ ये नहीं लिखा है कि सिर्फ पुलिस ही रेस्पॉन्सिबल हो सकती है। तो वो जो इस तरह की चीज़ें कहीं आएंगी तो इसमें इस तरह के कानून ये प्रोविजंस में कवर हो जाएंगी। Thank you.
I think we can wrap this session. Yeah, sure.
So about capacity building, I'd also like to add that it was not just teaching the law, but it was also about teaching about our police personnel, the technical gap that they had to teach them how to do photography, picking up digital evidence, to make hashtag values. So they were all also made to learn how to create hashtags. So I think there is a lot of learning which we have given to our staff. Of course, the people who will be actually going onto the field and doing the videography, photography, they will take some time to learn. They will learn from their mistakes, like the law evolves over time. Even our judges and our lawyers will also then guide us as to where we are making a mistake. But I think that's part of the ongoing learning. But as far as the critical input about telling them what, where and all, and the supporting infrastructure coming up, we will, I think, come up to their expectation.
So we've really overshot the time, so I'm sorry. We'll have to close the questions here and go on for the tea and then the last session.